Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Thank you for joining us for this third podcast in K&L Gates series discussing pandemic-related investor-state dispute settlement, or ISDS. This series is part of the K&L Gates Pandemic ISDS Toolkit, available on the website of the International Arbitration Practice Group at www.klgates.com. I am Raja Bose, a partner with K&L Gates Straits Law, LLC in Singapore, and one of the K&L Gates International Arbitration Practice Group coordinators. Today's discussion will focus on investor-state arbitration in the context of investment disputes arising from government measures taken to fight the COVID-19 pandemic, but specifically from the perspective of host states. The first podcast in this series provided an overview of the topic, and the second considered this topic from the investor's perspective. I am joined today by my colleagues, Meredith, a partner in K&L Gates London office, Matt Weldon, a partner in K&L Gates New York office, Hena Sial, an associate in K&L Gates Doha office, and Rob Houston, a senior associate in K&L Gates Straits Law in Singapore. Before we get started, I would just like to note that this podcast series, like the others, is limited in scope as appropriate for a general audience and the applicable time constraints. The information in this podcast is not offered as legal advice, which should be obtained only from properly licensed legal professionals on the basis of the specific facts of a given case. And finally, all speakers appear in their personal capacities, and any opinions or views offered are those of the relevant speaker alone and do not necessarily reflect the opinions or views of K&L Gates LLP, K&L Gates Straits Law LLC, or any other entity or individual. Let us rewind to March 2020. For a few months, there has been talk about a virus that is potentially contagious, although no one seems to know much about it. As a government decision maker, you are also unaware of the full consequences of this public health challenge, and you are faced with a series of decisions to make. Should you go on with business as usual? Should you adopt measures in an attempt to limit the health or economic impact of the COVID-19 pandemic? Do you really have a choice in the matter? The COVID-19 pandemic has prompted sweeping changes in the regulation of private sector commercial activity across the globe. As a host state, you may have implemented a variety of measures, including social distancing regulations, the closure of borders, export and travel restrictions, measures that had the effect of suspending certain contractual rights, requisitioning or nationalizing private property. There may even have been bailouts of state carriers. Even in times of crisis, however, it's important to bear in mind that states have ongoing and pre-existing international law obligations. Depending on the circumstances, measures that impact foreign investors as part of the state response to the COVID-19 pandemic may give rise to claims in investor-state arbitration. This is why, for example, the United Nations Conference on Trade and Development, UNCTAD, has observed the following, and I quote, "State measures to limit the adverse economic impact of the pandemic are manifold and vary from one country to another. Although these measures are taken for the protection of the public interest and to mitigate the negative impact of the pandemic on the economy, some of them could, depending on the way they are implemented, expose governments to arbitration proceedings initiated by foreign investors under IIAs, International Investment Agreements, and or investor-state contracts." End quote. This is an important issue. As a representative of a host state, you may be concerned that some government measures that your state has put in place may give rise to pandemic-related claims in investor-state arbitration. Before we consider this in detail, however, let's zoom out for a second. You might be wondering about the wider context in which these claims would operate. Ian, what are your thoughts on the bigger picture?
One of the first questions to address is what is the applicable law? Whether a state has breached an obligation to protect investment in an investment treaty is a question to be determined under public international law and not the domestic law of the host state. This is why we should first understand a bit about the fundamentals of public international law. The two primary sources of public international law are conventions, such as investment treaties between states, and international custom, the elements of which are state practice and opinio juris, which has been defined as a general recognition by states that the practice is settled enough to amount to a binding obligation. If there's a conflict between the text of an investment treaty and customary international law, the more specific law may govern over the more general law.
Thank you for that, Ian. So the resolution of an investor-state dispute, including one arising from a pandemic-related claim, may involve the application of the terms of applicable international investment agreement and of customary international law. Rob, what are your thoughts as a host state? I've adopted measures that I thought were best given the circumstances and the limited information I had available. Can I, as the host state, still be held responsible for breach of investment treaty obligations during a pandemic?
This is really the key question that will be considered in the near future, and time will tell how tribunals will resolve it. Host state representatives may be wondering, well, all the measures I adopted were permissible under my country's law, so shouldn't that be enough? There are a few key points, however, that are important for host states to keep in mind. First, the starting point in approaching such disputes, along with the text of the relevant investment treaty, would be the International Law Commission's draft articles on responsibility of states for internationally wrongful acts, or the ILC articles. The ILC articles have been recognized by courts and commentators as in whole or in large part an accurate codification of the customary international law of state responsibility. Under the ILC articles, an internationally wrongful act requires two elements. First, the conduct in question must be attributable to the state under international law, and second, the conduct must constitute a breach of an international obligation of the state. We'll turn to state attribution in a moment, but for the purposes of determining responsibility on the part of the host state, the ILC articles importantly provide that the characterization of an act of a state as internationally wrongful is governed by international law, so it's not internal law. Even so, host states may be able to rely on certain circumstances that preclude wrongfulness as a defense to pandemic-related claims from investors. It is important to note that these defenses do not terminate the underlying obligation itself. Instead, they provide a justification for the non-performance of the obligation in question while the circumstance persists, for example, perhaps during an ongoing pandemic. Let's have a look at a couple of the possible defenses under customary international law. First, force majeure under ILC Article 23, and second, the defense of necessity under ILC Article 26. With regard to force majeure, the commentary of the ILC articles reminds us that in order for a host state to rely on the defense of force majeure, three elements need to be met. First, the act in question must be brought about by an irresistible force or an unforeseen event. Second, that event must be beyond the control of the state concerned. And third, that event must make it materially impossible in the circumstances to perform the obligation. This is a high standard to meet. So, when thinking about force majeure as a defense in investor-state arbitration, host state representatives may be considering questions like, were subsequent waves of the COVID-19 pandemic unforeseen events? Did the COVID-19 pandemic make it materially impossible for the host state to fulfill its treaty obligations? Was there an element of free choice in the matter? This is going to be a difficult analysis. There's a similar situation with regard to necessity under ILC Article 25. The commentary to the ILC articles describes situations of necessity as those exceptional cases where the only way a state can safeguard an essential interest threatened by a grave and imminent peril is, for the time being, not to perform some other international obligation of lesser weight or urgency. The difficulty that host states may face with this defense is that the conduct taken by the host state must be the only way for the state to safeguard an essential interest against a grave and imminent peril. This, once again, may be a very high threshold to meet. Traditionally, these defenses have rarely been successful, but the pandemic may very well test their application in a new and global context.
Thank you, Rob. Let's talk a little bit about the first condition, state attribution. Hena, could you elaborate a bit more on state attribution? Why should states concern themselves with this?
Sure, Raja. As Rob mentioned, in order to establish the existence of an internationally wrongful act, the conduct in question must be attributable to the state. But what constitutes the state? Now, as you know, the state carries out its actions through people at different levels of government. ILC Article 4 provides that the conduct of the organs of the state will be considered an act of that state under international law. This means that actions taken by government departments, ministries, or other organs of the state at a provincial level or a local level could all be attributable to the state. This includes the legislative, executive, and judicial branches. There's no specific category here, and the ILC commentary on this section provides that virtually any state organ may be the author of such an act. It's not just the conduct of state organs that host states need to be concerned with. The conduct of entities exercising elements of governmental authority can also be considered an act of the state under international law, and this is further explained in ILC Article 5. The ILC commentary to this article clarifies that the intention behind this article is to take account of parastatal entities which exercise elements of governmental authority, and also situations where former state corporations have been privatized but retain certain public or regulatory functions. There is one caveat here, though. The entity or person must be acting in that capacity in the particular instance. Host states should also be aware of the implications of ILC Article 8. As a general principle, the conduct of private persons or entities is not attributable to the state. However, ILC Article 8 reminds us the conduct of a person or a group of persons shall be considered an act of a state under international law if the person or group of persons is in fact acting on the instructions of or under the direction or control of that state in carrying out that conduct. With these principles in mind, host states should consider carefully what conduct may be attributable to them as a matter of international law, whether it is the conduct of a state organ or otherwise.
Thank you, Hena. This is definitely a lot for host states to consider. Now, Matt, let me turn to you. Are there any limitations on claims that investors may otherwise bring under investment treaty that host states should keep in mind?
Yes, limitations may be described as limitations on jurisdiction, that is, limitations relating to the tribunal, or as limitations on admissibility, that is, limitations going to the claim itself. While the distinction between limitations on jurisdiction and limitations on admissibility is a real one, it is not uncommon for certain issues to be viewed inconsistently in practice from one tribunal to the next. This has real practical importance since, for example, a defect in admissibility may preserve a tribunal's jurisdiction over the broader investor-state dispute and allow the claimant to pursue claims previously found inadmissible if the inadmissibility is found to be cured by the tribunal. A defect in jurisdiction, on the other hand, may result in a claimant's inability to pursue its claims before a tribunal at all. So limitations may also generally be categorized on the basis of subject matter, time and/or certain characteristics of the investor's pursuit of the claim. Such limitations are specific to the circumstances of a given dispute, including the language of the relevant investment treaty or other legal instrument, and they are important. Identifying limitations like these early in the proceeding of engaging with an investor can be critical to the cost-efficient resolution of disputes in investor-state arbitration. As a result, when recognizing and responding to claims in investor-state arbitration, a comprehensive review of any applicable limitations on claims should be conducted as part of the initial consideration of the facts of the case.
Thank you, Matt. To sum it up, the COVID-19 pandemic has presented an unprecedented and fast-developing challenge to host states, particularly since the investment protection landscape remains relevant in investor-state arbitration, even with respect to pandemic-related claims. Whilst the determination of whether an investor may be entitled to compensation under investment treaty is fact and treaty specific, an awareness of the prospect of such claims is important, especially for host states that may face such claims in the coming years. Thank you to our speakers today for joining in this important discussion, and thanks to all our listeners for tuning in to this third and final podcast in our series on pandemic-related claims in investor-state dispute settlement. Goodbye for now.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.